5 seconds to go. Start. The act complained of must be integrally connected or directly linked to his duties as a public servant for the purpose of affording protection under Section 197 CRPC. Hence, it is not the duty which requires an examination so much as the act itself. One of the foremost tests which was laid down in this regard was whether the public servant, if challenged, can reasonably claim that what he does in virtue of his office. Later, the test came to be remodulated. It was laid down that there must be a reasonable connection between the act done and the discharge of the official duty, and the act must bear such relation to the duty such that the accused could lay a reasonable but not a pretended or fanciful claim that his actions were in the course of performance of his duty. Therefore, the sine qua non for the applicability of this section is that the offence charged, be it one of commission or omission, must be committed by the public servant either in his official capacity or under the colour of the office held by him, such that there is a direct or reasonable connection between the act and the official duty. If, in performing his official duty, the public servant acts in excess of his duty, the excess by itself will not be a sufficient ground to deprive the public servant from protection under Section 197 CRPC if it is found that there existed a reasonable connection between the act done and the performance of his official duty. It is the quality of the act that must be examined, and the mere fact that an opportunity to commit an offence is furnished by the official position would not be enough to attract Section 197 CRPC. The legislature has thought fit to use two distinct expressions, acting or purporting to act. The latter expression means that even if the alleged act was done under the colour of office, the protection under Section 197 CRPC can be given. However, this protection must not be excessively stretched and construed as being limitless. It must be made available only when the alleged act is reasonably connected with the discharge of his official duty and not merely a cloak for doing the objectionable act. There cannot be any universal rule to determine whether there is a reasonable connection between the act done and the official duty, nor is it possible to lay down such a rule. However, a safe and sure test would be to consider if the omission or neglect on the part of the public servant to commit the act complained of would have made him answerable for a charge of dereliction of his official duty. If the answer to this question is in the affirmative, the protection under Section 197 CRPC can be granted since there was every connection with the act complained of and the official duty of the public servant. The provision must not be abused by public servants to camouflage the commission of a crime under the supposed colour of public office. The benefit of the provision must not be extended to public officials who try to take undue advantage of their position and misuse the authority vested in them for committing acts which are otherwise not permitted in law. In such circumstances, the acts committed must be considered dehors the duties which a public servant is required to discharge or perform. On an application of the test as aforesaid, if on facts it is prima facie found that the act or omission for which the accused has been charged has a reasonable connection with the discharge of his official duty, the applicability of Section 197 CRPC cannot be denied. At the cost of repetition, we say that the position of law on the application of Section 197 CRPC is clear that it must be decided based on the peculiar facts and circumstances of each case. This court has held in a legion of decisions that any misuse or abuse of powers by a public servant to do something that is impermissible in law, like threatening to provide a tutored statement or trying to obtain signatures on a blank sheet of paper, causing the illegal detention of an accused, engaging in a criminal conspiracy to create false or fabricated documents, conducting a search with the sole object of harassing and threatening individuals, amongst others, cannot fall under the protective umbrella of Section 197 CRPC. In light of the same, it follows that when a police official is said to have lodged a false case, he cannot claim that sanction for prosecution under Section 197 CRPC was required, since it can be no part of the official duty of a public official to lodge a bogus case and fabricate evidence or documents in connection with the same. On examining the quality of the act, it is evident that there exists no reasonable or rational nexus between such an act and the duties assigned to the public servant for the claim that it was done or purported to be done in the discharge of his official duty. The mere fact that an opportunity to register a false case was furnished by the official duty would certainly not be sufficient to apply Section 197 CRPC. Allowing so would enable the accused to use their status as public servants as a facade for doing an objectionable, illegal, and unlawful act and take undue advantage of their position. If the case crime number 967 of 2007, registered at the Murad police station Gwalior by respondent numbers 3, 4 and 5 respectively, was a false case, then there is no doubt that the refusal to grant sanction would not operate as a bar for their prosecution. Moreover, as far as the case of respondent number 1 is concerned, it is an undisputed fact that he was not even posted as the SHO or TI at the Murad police station when the said false case was registered. The same is evident from the affidavit submitted by the IO at Firozabad before the High Court. Additionally, the respondent number 1 has himself admitted in his submissions before us that he was in fact posted at district Shivpuri, which is 120 kilometers away from Gwalior, during the relevant time. Therefore, any act or offence committed by the respondent number 1 in the present case can safely be said to have been outside the scope of his official duty, which obviates the question of sanction for his prosecution. Having said the above, the question whether sanction is required or not is a question that may arise at any stage of the proceeding. There might arise situations where the complaint or the police report may not disclose that the act constituting the offence was done or purported to be done in the discharge of official duty. However, the facts subsequently coming to light may establish the necessity for sanction. That the necessity of sanction may also reveal itself in the course of the progress of the case, as was laid out in Metajog Supra as follows. Stop.